Gratitude to all the seniors who should have gone before me, who have been kind enough to let me go before them. I'll just keep it very brief. There are just 4 points that I want to make. If your lordship would be kind enough to have volume 4B, B for Bombay.
What is the first point that you would make? So then we'll take it.
I'll address the 4 points. The 4 points are these. First, that in identifying the scheduled castes and scheduled tribes, a bit of a historical context is necessary, because eventually we're talking about how you will classify within these groups for the purpose of giving them measures. So the historical context will broadly show you how they first come to be identified. Why are they forever called scheduled castes? Where does that schedule come from? It comes from the Government of India Act 1935, and there's a background behind it. It starts with the census in 1891. I'll briefly touch upon that. All of that is in volume 4B. The second, this will also briefly touch upon that question that fell from the bench yesterday about why tribes, the word is used while defining scheduled castes.
In 341 also.
Yes. Why is it used there as well as in 366? In both places, scheduled castes are including tribes. Why does that happen? The second, Manoj, is that the constitution and its approach towards scheduled castes and scheduled tribes. You'll find that it was a very, very important and integral part of our constitution making, starting from the Pune Pact, starting from many other big leaders, both from the Dalit community and outside, who were responsible for ensuring that many provisions of the constitution were infused with this, with taking steps. Article 15, which has provisions which come from the Pune Pact, Article 17 and its abolition, exploitation provisions in 23. All of these, along with 15, 16, yes, of course, that's what we keep dealing with. But we must draw a small distinction between 15 and 16, which are provisions which are not automatic, which don't immediately give a right to a member of the backward community. It is for the state to make a law under 15, 16 if it so wishes. So 15, 16 are enabling provisions. 330, 332 and the provisions dealing with municipalities and panchayats give them a right. So how that started and that context under the constitution will perhaps help, I think, this bench in looking at the context in which we are arguing this case. Because in my view, at least my submission is that this subclassification is to be done at the end when the enabling provision is being activated. It is at that end that you decide while dealing only with 15, 16. That subclassification cannot be, and I think it came in the discussions earlier today, in 330, 332, etc. That can't be done. It's on 15 and 16.
Or the Panchayat Raj and municipalities.
Yes, or panchayats or municipalities. That's the second limb of the submission.
Yes.
The third, it's been touched upon by Mr. Sibal. I won't spend too much time on it. That error in Chinnaya, while looking at the Thomas paragraph of Justice Krishna, in fact, I'll make this point right away. It's just that this is an editorial intervention, an unnecessary editorial intervention in the SEC volume, which has caused this confusion. What exactly happened is in N.M. Thomas, Justice Krishnaiyer uses the word they, They. He uses that to refer to the various groups, etc., who are the Dalit community. He says that they aren't part of the Hindu groups. Unfortunately, when the editor published in SEC this judgment, within brackets, it put SIC, SIC, there, THEIR. Now that there is treated by Justice Hegde in Chinnaya to mean, therefore, a complete homogeneous group. They and there made a big difference. I'm just making this submission. The Lordship may see those two paragraphs, but I don't want to spend too much time on that.
Right.
And finally, there are a few questions that fell from your Lordships yesterday. I just want to address each of them. I think there were some doubts that your Lordships had. So I'll just do that briefly. If your Lordships, the first main limb is going to be the first two, 4B, volume 4B, B for Bombay, of the compilation. And I'll quickly go through that.
Editorial mistakes can sometimes cause very grave blunders.
Correct.
In fact, when we wrote I wrote the 7-judge judgment on the Arbitration Act.
Yes.
It was an editorial blunder in one of the private publications which was handed over to the bench.
Oh.
which pointed out that a particular provision was brought into force when it was exactly to the contrary.
Oh, it wasn't brought in. Okay. Well, that's very risky, Manoj. 7 judges we should.
And
be
it
careful.
was, so we noticed that and corrected the error in 7 judges.
Good. Well, so if I can trouble your lordships with volume 4B. 4B for bomb. I'm sorry. Yes.
What is the fourth? Volume 4B?
4B. B for Bombay.
This is your fourth point.
No, this is a volume for my first point. I'm just taking your lordships to the compilation. Compilation, volume 4B.
Volume 4B.
Yes. Yes. Not right now. 4B, my lords, if your lordships will take the first page, that's the census report of 1891. The lordships have that? Census, that's page 2 PDF as well as running page.
No.
No.
That is Dr. Ambedkar Foundation, that is writings and speeches.
Volume 4B for Bombay? 4B?
4B.
Dr. Asa Ambedkar writing and speeches, chronology of events.
What's the nodal council?
No, I've been told.
No.
No, we have downloaded it as Roman. It's Roman 4B.
Roman 4B.
It's for others also. It's census report. I'm sure. Sorry if there's.
Roman 4B.
Huh? The one your lordships are referring to is 4A.
4B.
Oh, 4B. Oh, I'm sorry. Then would your lordship check 4A? Because we've all been told that it's 4.
Also has some reference to Norway incident which Mr. Faraz yesterday mentioned.
Okay. So I'm sorry.
4A has Constituent Assembly debates, etc., etc. The tyranny of merit, Michael Sandel.
Let me check which volume this is.
Meritocracy trap.
Huh? Could you
I can wait in.
Just take it. 4C, 4D. Sorry. 4B. Oh, this is. Yes. What are you saying? No, let it be. I'll just address them. No, it's filed a volume. The file compilation. It's not there. No, we checked with the nodal council. He said it's been uploaded. If it's not, I'll just anyway address your lordships then. It's going? We'll go right now? Okay. But they'll just uploading it. I'll just address your lordship. I don't want to take time. I'll just briefly tell your lordship what it is. There is an 1891 census report. It was the first census report. Now that census report went into a detailed enumeration. At that point of time, what they did is they went through occupations because throughout the 19th century, the British had come up with many reformist processes from their end as far as the Hindu community largely was concerned. Your lordships know everything with reference to Bentinck's reforms, etc. But towards this end, they wanted to find out what the various occupations were because they found that within the large Indian communities, you would not have intermarriage, you would have people living on the edges, not allowed to share water, not allowed to eat, etc. together. And they looked at the various occupations because many groups were being excluded completely from the occupations. So occupation-based census is this one of 1891. And this provides for the manner of the enumeration, the classification of the occupation, and they specifically say that with reference to these, what they came to refer to as depressed classes, that's the phrase that they used to use then until it was dropped in 1935. The depressed classes, they said that there were many, even within the Rajputs and the Jats, they didn't look at them as castes, they looked at them as tribes. That is where, Manoj, this notion of tribes for the purposes of the depressed classes. We are not right now talking the scheduled tribes, scheduled castes. With reference to them, they referred to them as tribes. And they mention community-wise the various groups which are dealt with, which includes 10 minutes. the various tribes. And they divide them into various classes. Class Roman 7. Class 7 are known as the menials. Those are the ones today who have been come to be described as the scheduled caste. This is stage 1, 1891. The next one is 1930, which is the Indian Statutory Commission, which goes in detail into these depressed classes. The phrase depressed classes eventually came from a report of 1918, which became a part of the Montague-Chelmsford reforms. But they refer to they use the phrase, employ the phrase depressed classes. They look at these statistics from previously and say nearly 20% of the population belong to these classes. They say that these classes are partly functional and partly tribal, and they mention the various types of disabilities that these groups have been suffering over a period of time. The 1931 census is the third in this sequence. And it was carried out by a famous anthropologist at that time, Mr. Hutton. And he says, for the first time, he refers to primitive tribes. This is where the concept of scheduled tribes come in. They say that there are many tribes because the exploration of India for the British census takers was taking time. So they reached Nagaland, Arunachal, etc., and discovered many tribes which are nomadic or in jungles and forests, etc. And they refer to them as primitive tribes who haven't really come in contact too much with society. And they refer to them. 1931 is the first time that you find that there are these primitive tribes as well. This is for the purpose of the identification. And they shift in 1931 from depressed to referring to them as the ones formerly known as untouchables, and say that we shall refer to them as the scheduled caste. Now, the reason why scheduled caste is that in Government of India Act 1935, they eventually laid down that for representation in the federal legislature, there would be a first schedule to the Government of India Act, which would provide how the various communities were going to be represented. Now that, I think they're just transferring it. That is the one thing I'd like your lordships to see. Because all these communities that you find, where did in 1950 did the president suddenly get this list? He got this list from the first schedule of the Government of India Act 1935.
Right.
And we continue to refer to it as scheduled castes and scheduled tribes because of the schedule in the 1935 Act, nothing to do with the Constitution itself.
Right.
It's come. Can your lordships now see it, Manoj? It's on screen.
Yes.
Yeah, I can see that. It's good. Just if I can trouble your lordship, I've told your lordships the first, that's the 1891 census report. Then the next is that statutory commission report. There are page numbers. I'll give that to you in a single note, my lords, because I want to keep it short. And then is the 1931 census. And then the Government of India Act 1935. If your lordships would be kind enough to come to page 58. That's where the
I
act
didn't do
starts.
this, Ms. Shankar-Narayan.
Yes.
Today you have cleared the court, but you can add to your submissions
Yes.
just an addendum
Yes,
and make sure it goes into our copy.
I'll do that.
So that, then you can also, we'll label this particular compilation as volume whatever.
Yes,
You can give us a 2-page note
I'll
on
do-
the evolution.
I'll do that.
And I think that
this is why I'm trying to keep it short. I'll just highlight what I'm saying. Just for a minute, if I can trouble your lordships only with, of this volume, page 185. This is the first schedule. The lordships can see that. It's marked. It's the first schedule to the Government of India Act. And in this, my lords, entries 4, 8, 18, and 20. Your lordship may note that. Entry 4, for example, I'll just read to your lordships. To each governor's province, chief commissioner's province, and community specified in the first column of division 1 of the table, there shall be allotted the number of seats specified in the second column opposite to that province or community, and of the seats so allotted to a governor's province or a chief commissioner's province, the number.
Was the expression scheduled caste defined in the, and
It is defined. It is defined in 26. Yeah, but I'll just, 4, 8, 18, 20 refers to scheduled caste.
Yeah.
And 26 defines scheduled castes. So just, it's the exact same definition that you find now in the Constitution of India. 26. Can they go down? Can you scroll down? 26. That's at, I'm sorry, that's at page 189, PDF 189, the middle of 189. Yes, the scheduled caste means such castes, races, or tribes, or parts of or groups within castes, races, or tribes, being castes, races, tribes, parts, or groups which appear to His Majesty in council to correspond to the classes of persons formerly known as the depressed classes, as His Majesty in council may specify.
Same schedule.
So this is copy pasted effectively and put in the constitution. Immediately after this is the scheduled caste order of 1936 by the King and Council, Manoj, which is at page 253. It's very interesting. The previous year, 1935, Government of India Act is by George V. This is by Edward, who abdicated, as your lordships remember,
Yes.
because of that. So in the 1 year that he was king, page 253, this is issued, first paragraph, page 253. Whereas by certain provisions in the first, fifth, and sixth schedules to the Government of India Act, His Majesty in Council is empowered to specify the caste, race, or tribes, or parts of the groups within caste, race, or tribe, which are to be treated as the scheduled castes for the purpose of those schedules. And it's not only schedule 1, but other schedules as well, as you'll find from para 2 of this in the middle of the page. Subject to the provisions of the order for the purpose of so-and-so schedules, these are the ones who will be specified. Para 3 is interesting. It says, notwithstanding anything in the last preceding paragraph, no Indian Christian shall be deemed to be a member of the scheduled caste. No, in Bengal, no person who professes Buddhism or a tribal religion shall be deemed to be a member of the scheduled caste. This is after the partition of Bengal.
Yes.
And next page onwards are the castes. So these are the castes, tribes, all of them, state-wise, as per those states, Madras, etc. Now, this in its entirety, this goes on for several pages more. This in its entirety, community-wise, was what was replicated in the presidential order of 1950. The presidential order had to be amended a few times every time we had a reorganization of states, because it was unclear whether that community will remain an SC for that partitioned state or not. So they did. Every time there was a reorganization in 56, 59, they did actually amend the presidential order of 1950. I'm quickly coming to my second limb. This is to give your lordships context and to say that these are the groups. Therefore, at a later stage, when you come to enabling provisions, when you decide to give those communities, if some of those communities have been, say, for 16, adequately represented, then it is incumbent on the state not to repetitively give them, who are adequately represented, that benefit. I think that point has already been made repeatedly. Second, I'm just handing this over. It's there in this volume as well. It's there in the volume, yeah? Just take 7 copies. This, Maloj, is something I had submitted in the EWS reservation case, the 5 judges, just which has been included in the Janhit Abhiyan judgment, in fact. It's a chart showing reservation provisions under the Constitution. All the provisions are here, which are dealing with this, just to help address your lordships on. It's in this also. It's at page 805 of this volume. It's at page 805, but I'm just addressing it from here, if I may. This is to show the provisions, Malons, which govern each of these communities. The central one, the red one, is SC/STs. The one outside that is SCBC, OBCs. And the one at the outermost is EWS. We can ignore EWS for the time being. SC/ST, the definition provisions are there. Then the special provisions are there. Now, why we have color-coded it separately is for the parameter that has to be applied. The parameter that has to be applied for the scheduled castes and scheduled tribes with reference to 15 and 16 is historic untouchability. Because I think there has been a general sense that social and educational backwardness is the determinant for being an SC/ST. That's not true. For being an SC/ST, it is about its historical backwardness and it's a constitutional atonement for those years of discrimination. So for determining who the scheduled castes are, and this is what even the 5 judges decision in Mari Chandrasekhar says. Specific paragraph I'll give you, it's para 9 of Mari. Mari is, I'm sorry, it's not part of this volume, but the paragraph is extracted. It says that it's the historic untouchability which is for the determination of SCs. Social and educational backwardness, which is defined in the Constitution in Article 366, says for the purposes of this Constitution, socially and educationally backward are those who are determined by way of the list which the President provides. But that came in by way of an amendment, that definition, because after the Indira Sawhney judgment, the Indira Sawhney judgment gave one direction to the government. It said that please ensure that you set up a national commission for the backward classes, and they set up a national commission. There was a National Commission of Backward Classes Act. Subsequently, when the constitution came to be amended, that national commission was taken and put on a constitutional plane from statutory to constitutional. And therefore, the definition had to be given of who are socially and educationally backward classes. Now, there has been a little bit of debate in the past whether socially and educationally backward classes is the phrase used in 15. It's not used in 16. In 16, you say backward classes, which is why you get the O in the OBC. You have SCs, STs taken anyway to be backward classes for purpose of 16. Other backward classes are those outside of that. Are they the same as the SCBCs? The Constitution seems to suggest to us, courtesy all these amendments that have come, that they're perhaps the same. We don't have a fourth list of OBCs. We just have the SCBC list. That's the one that's adopted. But for determining the scheduled castes and scheduled tribes,
Historic untouchability.
it's historic discrimination. So that pink one shows that that's historic untouchability. Now, the reason why I put the blue ones, your lordships will see,
The political backward,
political backward.
political reservation.
So in municipalities and panchayats where you have these provisions, as well as in the Lok Sabha and the legislature, these are the political backwardness determinations that have to be made. The third, of course, are the social and educational backwardness, which are in yellow. Now, one small distinction, I think, which is essential for answering the question that has been referred to your lordships is simply this, that the idea in the Constitution at the time the Constitution came in, the SC/ST communities had only one provision of reservation to them, which are the ones in 330 and 332, nothing else. As a provision of reservation available to that community, it was only in the legislatures and parliament. Subsequently, when enabling provisions were activated from the outset, from Champakam and Venkatraman, both decided in 1950, or one on 15 and the other on 16, there was an activation of that. Even though the GO was prior to the Constitution, there was an activation of 15 and 16. Once you activate 15 and 16, does the state not have the right to say that, look, your list which the president has made, that remains intact. I'm not trifling with it. But for my purposes, where 15 and 16 gives me the right to make a measure,
Yeah.
I believe that these communities need to be favored. Now, whether the choice of those communities by me is right or wrong will be determined based on reports, based on other data. The Indira Sawhney judgment says use the barium chemicals measures to determine that. But that list remains intact for the purposes of the political representation. So for municipalities, panchayats, legislature, and Lok Sabha, I can't touch it. The state has absolutely no role to play in that. That remains. I hope I'm making myself
Yes.
clear. So that distinction is necessary. This entire debate here is really only about 15 and 16. Because the definitions, both in 340, 342, as well as in 341, 42, as well as in 366, make it clear for the purposes of this constitution. So the SC/ST determination or definition for the purposes of this constitution encompasses the mandatory political representation for which the state has no role to play at all. It can't interfere in any way. And where the state has a role to play. It's only in that where the state has a role to play under 15 and 16 that it is the entitlement. In fact, it's a constitutional obligation of the state to make such determinations. So this chart is for
I think,
that
Mr.
purpose.
Shakhandan, we've got the point. Should we
Yes.
now close?
The last thing is to address those questions. Well, one more. There's a judgment of your lordships, which is in this compilation at page 353, my lords. This is a small concept which may be relevant. This is a judgment of, my lord, the Chief Justice and Justice Shah in 2021. This is at page 353,
Yes.
Patan Jamal Wali. It was dealing with the outrage, the rape of an SC/ST lady who was also blind. Now, two paragraphs just see para 17 at page 372, internal 372, para 17.
Yes.
This principle of intersectionality, I comment to this bench. Intersectionality can be defined as a form of oppression that arises out of a combination of various oppressions, which together produce something unique and distinct from any one form of discrimination standing alone. While the model of intersectionality was initially developed to highlight the experiences of African American women, there is a growing recognition that an intersectional lens is useful for addressing the specific set of lived experience of those individuals who have faced violence and discrimination on multiple grounds. A single axis approach to violence and discrimination renders invisible such minority experiences within a broader group, since it formulates identity as totemic and homogeneous, which is precisely what Chinaya has done. Each of these communities have lived experiences which are distinct from each other. Even in Indra Sawhney, I'll give you a lot of the paragraph, there is a acceptance. Justice Krishna and Anam Thomas says that even within the scheduled castes, they're not all alike. They're all very, very different. They have different experiences. But I won't read the rest of the paragraph, but I believe this paragraph
Yes.
and
Para.
para 795 of Indra Sawhney. Both of these, your lordships may just consider. Now, quickly, I'll just address the questions that came yesterday. Justice Nath had asked a question that once people have achieved to a certain extent, wouldn't you remove them from the list? That's not a call for the state to take for two reasons. One, that they don't have the power, that's for the president to do on recommendations by the state. But when you remove, when they've reached that level, you have to see that they've reached that level not only in my domain of 1516, which is education and employment and everything else
Why
socially.
can't the state take that call? State
No,
can always
because
do it.
the removal
Once
from
state
the-
is deciding to
Yes.
allocate extra percentage of reservation for specific communities
Yes.
within that scheduled caste group.
Yes.
It can say that these are already adequately represented, they don't require any reservation.
Yes.
Why not?
No, so the
That the
problem is
state has
this,
to implement
the
41.
under 15 and 16,
Yes.
it becomes implicit because the state, when it's giving its reservation, says, I choose these 10 communities and I give it to them. So the
64
others get excluded.
64 is backward class.
Yes.
You can always say this backward class does not require any further.
No, I
reservation
don't think the
because it is
negative
adequately
declaration
represented.
is necessary
It's a
when they
state
positively.
exercise, not the
So
parliament exercise.
So if they give the entire extent of their reservation,
They can
so say
continue
10
the scheduled caste
communities.
to gain
Yes.
advantage of 15(4)
Yes.
or any other provision.
No,
Or
so-
330 or whatever.
Yes.
But for
So-
16(4) is concerned.
Yes.
They can always exclude.
Yes, so that comes to the second question, my lord. The Chief Justice posed to the Advocate General yesterday. If there are only two communities and you decide, can you give entire 100% of the reservation to them? My answer is different. My answer is yes, you can. Because the idea of this constitution is that at some point you will, because you'll reduce from your 100 caste groups. Hopefully, we are moving forward as a nation. If you keep moving forward as a nation, some of these communities will get adequately represented, will move forward. So from 100, you'll come to 50, 40, 30, at some point you'll come to 2. And you'll say, look, these two are so terribly ravaged that there is no question that I'm going to give my 100% of that reservation available to me to them. Both the quantum, that is percentage, as well as the number of communities is in the state's hand. So the state doesn't have to give 40%, it can give 4% reservation and say the entire 4% will go to two communities. So that's to answer the second question, my lords, which I believe that would be the correct answer, the consistent answer, because this constitution and its interpretation not for today. When we have 7 judges going into this, 20 years from now, we may hopefully reach a stage where we will have only 2 communities and we'll be able to take care of them also.